Good evening, PBL 200 students. This is a talk through of the 2018 PBL 200 test. This was question 3. For future years, this will also be a resource to explain how this question should have been answered. So there was the question. Question 3 in the 2018 paper, 7 marks, and the question said the question is assessed in half marks. So 3.1 was a 4-mark question. That means it should have been at least 8 facts or 8 arguments, 8 items for the 4 marks. There were many more marks than the possible 8. The question then dealt with an articled clerk who applied for a position as an articled clerk at a firm of attorneys. If you read the facts carefully, he did not have a motor vehicle, he did not have a license, a driver's license, and apparently also did not fit the firm's look and feel. So 3 possible items that you could have addressed in your answer to explain why there was discrimination against the candidate. So it says, argue in favor of the candidate that the firm discriminated against him in terms of the Harkson versus Lane test. So not differentiation and not fairness or unfairness, only discrimination. So the starting point would be the authority. Now already in the question it tells you Harkson versus Lane, so no point in repeating that because we give that to you already. But the authority then, section 9(4) in the Constitution, that prohibits unfair discrimination. What is discrimination then? Differentiation based on a prohibited ground. In this case, the differentiation not based on a listed ground. In other words, back to what was said here, no motor vehicle, no driver's license, and does not fit the firm's look and feel. So there is no ground listed in section 9 in the Constitution that fits any of these. How then to deal with this puzzle? Clarkson versus Lane says that if you want to recognize further grounds, the test is if that ground has the potential to infringe the complainant's dignity. And then for each of these you have to show the differentiation. So back in each case, back to the definition, discrimination is differentiation based on a prohibited ground. Where does the differentiation lie? It lies between candidates who meet the firm's look and feel and those who do not. Or down here, though, differentiation between a candidate who meets, who has a vehicle and someone who does not. Or as well someone who has a driver's license and someone who just does not. So the starting point for all of these is the definition. Where does the differentiation lie? What is the potential prohibited ground? So, and then deal with them one by one. So what is the firm's look and feel? What does look and feel refer to? Probably physical appearance. Unless this was the firm's roundabout way of saying that you're not the correct color or race. But then you needed in your answer to explain that. How could you have made an inference that look and feel was supposed to mean race? And then if you felt that look and feel referred to physical appearance, then you needed to explain in your answer why would physical appearance, if you use that as a prohibited ground, why would that lead to, or why would it have the potential to infringe the complainant's dignity? And then the same with if you don't own a car or if you don't have a driver's license. Now, if you don't own a car versus a candidate who does, it's probably socioeconomic status or class. And it could also be indirectly based on race, because which candidates probably have a car before they even apply for a position. Many South Africans need the job to be able to afford a car. This firm now expects you to have a car already even before you're employed. So at least socioeconomic status that's implicated, maybe still race as well, given the South African socioeconomic setup in the country as to who already owns cars, who not, predominantly which groups, which race groups in South Africa already are in this position to have a car even before they apply for a position. But at the very least, socioeconomic status, and then the argument again has to be made, socioeconomic status not listed in section 9.3, why would that meet the test for the recognition of new grounds? Why would socioeconomic status have the potential to infringe a complainant's dignity? The argument around a driver's license, I think, is a bit different. You don't need to own a car to obtain a driver's license. So perhaps with driver's license, the argument is not so strongly in favor of the candidate. But at the very least, for look and feel, and for not owning a car, there seems to be a strong argument that it is either physical appearance or socioeconomic status. What many students did in this question is to jump straight into fairness, unfairness, which is not that what was asked. It was only asked whether there was discrimination or not. So the trick was to identify, or to start with a definition. Discrimination is differentiation based on a probated ground, then to identify the probated grounds and one by one deal with the different situations. Many students just chose one, just spoke about look and feel, or just spoke about not owning a car. But the question dealt with all three, was probably discriminated against on more than one of these items. So the answer really should have dealt with all of them. 3.2 then, for 3 marks, it was again marked in, the entire question was marked in half marks, so 3.2, that counted 3 marks. That would have been at least 6 things that needed to be mentioned here. Here the argument is that you had to argue in favor of the firm that the discrimination was fair. Now again, start with the principles. Hodgson versus Lane determined or explained that there were a couple of factors that needed to be considered once it was established that discrimination was present, and that we already, in 3.1, that call was already made that there was going to be discrimination. 3.2 then only deals with fairness in favor of the firm. First step is to write down the different factors that the Constitutional Court has already identified as to how to determine fairness or unfairness. There are others mentioned as well in section 14 of the Equality Act. Those would also have been accepted, but at the minimum these 4, the impact of the discrimination, the position of the complainant in South African society, the nature of the discrimination, the purpose of the discrimination. Now that would already have been 2 marks. Just for an additional 1 mark then to get to the 3 marks, you needed to apply these factors. Now if you're arguing in favor of the firm that the discrimination was fair, you would need to have argued that the impact was not so severe. So how would you be able to explain that? He doesn't get a job. That seems to be quite a severe impact, but you have to argue in favor of the firm. So you would have probably argue things like saying that it's only this firm that sets this requirement, that he already has a degree, he's already a relatively privileged member of South African society, already having a degree, and that he can find a job at another firm. That's maybe a way of getting around the impact. The position of the complainant in South African society, the candidate is a black male, which is historically a disadvantaged sector of South African society. But again, if you want to argue in favor of the firm, to say that this was fair discrimination, you would have to again go with something like he already has a degree, he's got good career prospects, that he's not particularly vulnerable. The strongest argument in favor of the firm is to use the purpose of the discrimination, that young clerks have to do many deliveries and that without a vehicle the firm is a bit stuck. There are obviously arguments in favor of the candidate why this discrimination is unfair, but the question asks you to argue in favor of the firm that the discrimination was fair. So you had no choice here, even if you disagree with the kind of discrimination that occurred here. The question said that you had to determine, or that you had to argue that the discrimination was fair. in marking this question in 2018, I did not keep a strict distinction between 3.1 and 3.2. Many students answered 3.2 in 3.1 already, not reading the question carefully, not seeing that was only about discrimination. Many students already dealt with fairness and unfairness in 3.1, so I would already have given you those marks in 3.1. While strictly speaking, I should have ignored it. For 2019 and onwards, we probably have to be a bit more strict about this to keep them separate, because it is a different requirement. To argue around discrimination as a very specific starting point, to argue around fairness and unfairness as a different starting point. These really are two separate issues that shouldn't have been dealt with all in one. But I did mark quite leniently in 2018 to try and still give students some marks for plausible arguments. Thank you.